Senator Pate.
Thank you, Mr. Speaker. Honourable Senators, this month marks Indigenous History Month and the 7th anniversary of our collective commitment to meet the calls for justice of the National Inquiry into Missing and Murdered Indigenous Women and Girls. Amid the ongoing crisis of missing and murdered Indigenous women, multiple declarations that violence against women is an epidemic, and repeated failures to respond, Bill C-16 is celebrated as a step forward, yet it embodies a dangerous step back from our senatorial duties. As this bill rushes through the Senate, I speak today to put on record the concerns we've heard from experts, frontline workers, and those with lived experience about the negative impacts for survivors of violence against women in connection with how this bill has proceeded, and to, at the very least, urge amendments to the bill's provisions on mandatory minimum penalties that will otherwise criminalize survivors, particularly Indigenous women. The government invokes the moral imperative of addressing crises associated with violence against women to insist on urgent passage of Bill C-16. If this was so urgent, why did the bill sit undebated in the other place as we implemented a pre-study, not to mention how it stagnated at committee there for nearly 2 months? The House committee heard from witnesses for over a month, yet we were expected to complete our parallel work in fewer than 4 days. Despite the disproportionate impact of this bill on Indigenous communities, the Legal Committee heard only one single Indigenous witness. If we do our job and fix deficits in this bill, we do so not knowing whether our elected officials will even still be in Ottawa to consider them, or if the House will rise for the summer. Why are we acquiescing with increasing frequency to situations that restrain our obligations and commitments to serve Canadians by carrying out meaningful review? Among the legislation that the government is urging us to pass before the summer, we find not one, but 2 bills riding on the backs of women. Bill C-16 and C-225 contain several near-identical measures, and the Senate has not had time to give either the careful study they should receive. On a topic as urgent, harmful, yet still too often dismissed and discounted as violence against women, this approach risks mirroring the apathy and complicity that have prevented meaningful action for far, far too long. Will what we are passing actually work for victims? Do we care? I believe we do care. We also should know that it will not work. Most witnesses, including the minister and many supporters of Bill C-16, caution that the bill focuses on just one tool, the criminal law power. Criminal law responses do not advance safety and protection of victims. They are relatively expedient for governments to invoke, but they are proven to be ineffective. Truly addressing intimate partner violence and coercive control means working to dismantle systemic inequalities that embolden and normalize misogyny, racism, and violence, and by building up health, housing, social, and income supports that women, children, every one of us need in order to be safe. Bill C-16's entrenchment of mandatory minimum penalties under the guise of protecting victims exemplifies and exacerbates ongoing deficits in equality and justice, as well as failures to address the way survivors of violence against women, especially Indigenous women, are invisibilized and not deemed victims, incarcerated and held responsible for their own victimization, including violence others inflict on them. As senators, we are tasked with representing the interests of those without power, resources, and privilege to make their voices resound within majority-driven spaces, especially in the other place. In that capacity, I'll be proposing at committee a modest amendment to the bill's provisions on mandatory minimums to ensure that at the very least they better reflect Canada's Truth and Reconciliation Commission and Missing and Murdered Indigenous Women and Girls commitments and Charter principles by ensuring that the safety valve extends to all mandatory minimums and allows alternatives to prison sentences. 9 in 10 women in federal prisons experienced physical or sexual abuse before they were criminalized. Each of these women is a victim whom our health, housing, social, economic, and legal systems failed to adequately protect and support. I have previously shared the layers of misinformation and injustice that led to the wrongful manslaughter conviction of Indigenous teenager Jamie Gladue, based on her characterization as a jealous wife, or, if we apply the terminology of Bill C-16, perhaps a coercive or controlling wife. This bill entrenches the near certainty of repetitions of such injustice. Nothing in Bill C-16 will ensure that our legal system will recognize another Indigenous victim of intimate partner violence, like Jamie, first and foremost as a victim, let alone protect her. In fact, through expanded approaches to first-degree murder and manslaughter, it will risk more women in her circumstances being induced to plead guilty and result in them being sentenced more harshly. The safety valve in Bill C-16, in addition to being so narrow as to leave people exposed to near cruel, unusual, and unconstitutional punishment, does not apply at all to mandatory life sentences. Mandatory life sentences discourage survivors from standing up to the misogyny and racism of our criminal legal system by asserting they acted in self-defense. At committee, witnesses emphasized that contrary to the government's intention of ensuring constitutionality of mandatory minimum penalties, mandatory life sentences will remain constitutionally vulnerable, especially in light of obligations to consider Indigenous history and context. The government's GBA Plus analysis acknowledges that Bill C-16 will increase the overrepresentation of Black and Indigenous people in prisons. When Senator Clément asked the minister about this finding, the minister stressed the importance of using race and cultural assessments and Gladue reports to help address overrepresentation. But these measures are the very ones that the safety valve paradoxically prevents judges from fully considering. The so-called Gladue principles that inform both measures, named for Jamie Gladue, though she never received their protections, appear in Section 718(2)E of the Criminal Code, which requires judges to consider alternatives to prison before sentencing anyone, but especially before sentencing Indigenous peoples. The so-called safety valve does not respect this legal requirement. It merely permits judges to impose shorter prison sentences rather than community-based alternatives. The provision thereby fails to honor the government's commitment through the Truth and Reconciliation Commission Call to Action number 32 to, quote, allow trial judges, upon giving reasons to depart from mandatory minimum sentences and restrictions on the use of conditional sentences, end quote. Bill C-16 also reinstates mandatory minimums that courts have ruled unconstitutional under this inadequate safety valve. Taken together, the so-called safety valve will mean the numbers of Black and Indigenous peoples in prisons will continue to rise. It will push Canada farther away from another TRC commitment, that of eliminating the overrepresentation of Indigenous peoples in prison by 2025, a now well overdue deadline. Victoria Perry of the Indigenous Bar Association, the sole, only one Indigenous witness at Legal Committee, emphasized the need for recognition of Indigenous laws and legal orders, including processes to refer matters, quote, out of the colonial court system and back into the Indigenous court process or Indigenous restorative process, however that exists within that community and context, end quote. The very limited safety valve creates yet another barrier to this vision of greater justice and to shared obligation as senators to represent minority groups, our shared obligation, to uphold equality and advance reconciliation. Senators also have a responsibility, as the government representative reminded us during debate on Bill C-9, to strengthen the government's duty to lead rather than to follow. I was heartened when Senator Moreau emphasized the obligation of the government to address misinformation about criminal law through public education. Regrettably, Bill C-16 represents a missed opportunity for such leadership. Canadians do not benefit when we appease demands for harsh on crime measures rooted in misinformation rather than heed and provide empirical evidence. Canadians expect their leaders to give them the facts and develop policies that work. At committee, government officials acknowledge that the Department of Justice's research has long recognized when it comes to mandatory minimum penalties, quote, there is little evidence of their effectiveness on deterring crime, end quote. The Supreme Court concluded the same, quote, empirical evidence suggests that mandatory minimum sentences do not, in fact, deter crimes, end quote. The Canadian Association of Chiefs of Police told Parliament that police services have differing positions regarding mandatory minimums. Some support them, some do not. Even the Canadian Police Association, a police organization supportive of mandatory minimum penalties, noted that, quote, if all we do is sentence people to jail without getting to underlying issues such as mental health, substance use, and poverty, we're not going to get to better outcomes ultimately, end quote. The victim ombuds emphasized, quote, access to safe and secure housing is one of the most transformative things we can be doing to protect survivors and improve public safety, end quote. Many of you will recall they also support guaranteed livable income for the very same reasons. The minister acknowledged, quote, that the long-term solution to crime, if it does not include upstream supports to cure social inequities, will be a failed effort across a generation, end quote. This year, Canada's federal prison system will cost taxpayers $4 billion. For that investment, we temporarily remove people from the community, but do not allow those who are victimized to experience social, economic, or health security. Abandoning people to desperate situations in communities, as well as in prisons, increases the risks of both victimization and criminalization. If we are serious about protecting women and children from violence, we must address the inequalities that too often trap them and keep them in unsafe situations. The government suggests that if mandatory minimum penalties do not actually deter violence against women, they at least send a message. But what is that message, honourable colleagues? Most women who survive violence never file a police report. Only a fraction of those reports result in charges. Far fewer result in convictions, let alone meaningful accountability. Those who are criminalized and imprisoned are not the only ones causing harm. They are often the easiest to catch. More powerful and privileged abusers, if ever confronted with their behavior, hire lawyers and experts, settle cases, insist on non-disclosure agreements, insulate themselves from responsibility, and continue on. What is the message we send through a criminal legal system where those with the least power and privilege who perpetrate violence against women become prisoners, and those with the most commit the same misogynist violence become and carry on, whether it's as podcasters, influencers, professionals, athletes, leaders, CEOs, presidents? All of us, especially men in places of relative privilege, including in this chamber and the other place, must step up, redouble our efforts, and model the behavior needed from our leaders and role models to uphold equality for all. In the absence of such leadership, Bill C-16 and other similar adjustments to criminal law will not address the roots of deep-seated colonial and misogynist inequalities and assumptions that actually fuel violence. Grafted onto existing inequalities, this bill could serve to co-opt and complicitly help to shield those with the most and punish those with the least, including victims themselves. I hope you'll ensure we fulfill our responsibility. Colleagues, let's do better. Miigwech, merci. Thank you.